Bonjour. Quaid. Hello. Mon nom est Jennifer Quaid. Je suis vice-doyenne à la recherche à la section de droit civil de l'Université d'Ottawa. Je vous souhaite la plus chaleureuse des bienvenues à cette conférence co-présentée par le cycle des conférences de la section de droit civil et le Centre de droit public à la Faculté de droit. Nous sommes vraiment ravis de vous avoir parmi nous en cette semaine de lecture. Tout d'abord, au nom de la section et de l'université, je tiens à souligner que les terres sur lesquelles se trouve l'Université d'Ottawa font partie du territoire traditionnel du peuple Anishinaabe-Algonquin. Nous leur rendons hommage et reconnaissons leur relation continue avec ce territoire qui demeure non cédé et dont ils sont les gardiens traditionnels. Nous rendons également hommage à tous les peuples autochtones qui habitent Ottawa, qu'ils soient de la région ou d'ailleurs au Canada. Nous reconnaissons les gardiens des savoirs traditionnels, jeunes et âgés. Nous honorons aussi leurs courageux dirigeants d'hier, d'aujourd'hui et de demain. Aujourd'hui, nous avons le grand plaisir d'accueillir le professeur Amar Khoday, qui est professeur à la Faculté de droit de l'Université du Manitoba. Today, Professor Khoday is going to talk to us about his brand new article that came out the beginning of this year in the Osgoode Law Journal and Osgoode Hall Law Journal, I'm sorry. And it's entitled Black Voices Matter Too, Counter-Narrating Smithers versus the Queen. For those of you in the audience who are familiar with Criminal Law 101, everyone has gone through the Smithers case. Almost everyone has had to read it and learn about it. It is taught primarily as a case about causation. And yet, every year, I will admit I'm one of those people who was uncomfortable with the fact that there's a lot that just is simply skipped over in a few lines in the decision written by Dixon. So today we have the chance to hear about what's behind those lines and what has often prompted questions from my students. And I think it's a really important story that has to be told. And I'm really delighted that Amar has agreed to talk to us today about it. And to the students in the classroom or in this crowd of Black screens, this is a real rare opportunity to hear something about a case that we all have to read. Sans tarder, je veux céder la parole maintenant à Christian Yao-Alou, qui est doctorant chez nous à l'Université d'Ottawa, Faculté de droit, et qui va nous présenter notre conférencier et mettre en marche cette conférence. Merci.
Merci beaucoup, professeur Jennifer. Alors, bonjour, mesdames et messieurs, chers professeurs. Je suis Christian Alou, doctorant à la Faculté de droit. Je rappelle que vous pouvez choisir votre langue d'interprétation en bas de l'outil pour vous sentir plus à l'aise concernant l'événement. Alors, j'ai le plaisir aujourd'hui de modérer ce rendez-vous d'apprentissage et de partage. Nous avons l'immense honneur, comme le professeur Jennifer l'a dit, d'accueillir au sein du Centre de droit public aujourd'hui le professeur Amar Khoday, qui en réalité n'est plus à présenter tant sa réputation lui précède. Professeur à l'Université de Manitoba, Dr. Amar Khoday joined the faculty at Osgoode Hall in 2012 as an assistant professor. In 2017, he was promoted to associate professor with tenure. Of course, he was student before Professor Amar earned his Doctor of Civil Law in 2014 and Master of Laws in 2008 degrees from McGill University's Faculty of Law and Juris Doctor in 2004 from the England School of Law in Boston. Il a aussi un baccalauréat et une maîtrise des arts, ce qui est encore très intéressant, avec une double spécialisation en histoire et en études de l'Asie du Sud de l'Université de Concordia. Récipiendaire par ailleurs de la bourse de recherche doctorale du Conseil de recherche en sciences humaines du Canada et de la bourse O'Brien pour les droits de la personne et le pluralisme. Dr. Amar research cover criminal law and procedure, refugee, immigration and citizenship law and policy, time and law, law and resistance, law and popular culture, legal history, legal narratives, race and the law. Ses travaux et ses publications sur des sujets complexes et délicats, mais qu'il arrive a abordé avec un style propre à lui, en fond, un chercheur de haut standing, reconnu et respecté partout. He is an exceptional communicator, as can be seen by many lectures he gives all over the world. In this Black History Month, and I need to recall that, we are curious to hear Professor Amar's thoughts on his article published in Osgoode Hall Journal, entitled Black Voice Matter Too, Counter-Narrating Smithers Against the Queen, published in 2021. Mais avant de laisser la parole au professeur Amar, je rappelle que vous pouvez poser des questions dans le Q&A pendant la communication de notre invité, et j'aurai le privilège de poser une ou deux questions juste après sa communication, avant d'ouvrir le partage au public. Alors, sans plus tarder, the word is yours, Professor Amar.
Thank you very much for that very kind introduction, Christian. So I'd like to thank Dr. Jennifer Quaid for your kind invitation to speak as part of the cycle de conférence, and as well, it's just a really nice joy to be here with so many faculty members, I think, from the University of Ottawa who have come to become friends of mine. I'd also like to extend my gratitude to the Public Law Center at the University of Ottawa for co-hosting and promoting this talk. And in particular, I'd like to thank its co-directors, Professors Terry Skolnick and Vanessa McDonnell. I'd also like to thank as well Mr. Christian Adou for agreeing to moderate the discussion after my lecture and for that very kind introduction. So merci beaucoup. So Black Voices Matter Too. It's part of Black History Month, and as part of that, I'd like to focus on legal stories. But before I get into that, I want to take a moment, just as Dr. Quaid did a land acknowledgement at the beginning. I'd like to do that as well for myself. So turning to slide 2. As was mentioned, I live in Winnipeg and I work at the University of Manitoba, and we have our own land acknowledgement. So the University of Manitoba campuses are located on the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. And focusing in on and thinking about the concept of acknowledging harms and mistakes of the past, I'd like to now focus attention on my paper, which examines an example of harms and mistakes of the past, but with respect to another community, and in particular, with respect to a specific individual, Paul Smithers. So turning to the next slide, please. Thank you. So Black legal histories. We're in the midst of Black History Month, and this gives us an important chance, an opportunity to focus on Black stories. And that includes Black legal stories. Given the discipline that we're in, it seems to make only sense to do so. And it's also important to remember that while Black History Month gives us a platform, a chance to think about Black stories, remember, stories are going on all year, and we should not forget to think about those year-round. But in focusing on Black legal histories, let's think about what histories have been told. How have they been told? And of course, who's told them? So in terms of what Black legal histories have been told, well, there's many that are out there. Certainly, and tragically, as with most legal stories and legal histories, they're often not happy ones, as anyone can imagine. And in connection with Black legal history, there's plenty of sorrow that's taken place, and stories about discrimination within sports, with respect to policing, the criminal justice system. It's not isolated to these moments, but it's certainly a part of that broader history. How have these stories been told? Well, certainly through case decisions. Stories are conveyed through witness testimony by defendants themselves, other witnesses. They're also told through books, scholarship, movies, popular culture. And who is told these stories? Courts, judges, lawyers, again, witnesses, and academics, historians, activists, journalists, a whole slew. And I just want to point out, there's within Canadian legal history, there have been a number of scholars who've talked about the intersection between race and Canadian legal history. I'm not going to give an exhaustive list, but a few are worth pointing out. We have books written and work written by Dr. Barrington Walker, Dr. Afua Cooper, Robin Maynard, and of course, University of Ottawa's own Professor Constance Backhouse in the Faculty of Law. I've also cited as well to Professor Eric Adams at the University of Alberta as part of this article, and there's so many more historians. Now, as part of this rich history of Canadian legal history and the intersections with race, what's interesting is one particular case has sort of escaped any real attention within the context of thinking about race and legal history. And that particular case is Smithers v. the Queen. Now, as Dr. Quaid mentioned before, this is a case that's talked about every year in pretty much every Canadian criminal law class. I'm pretty sure. I'm making an assumption there, and it's usually part of probably the first case in a suite of decisions connected to causation. We start perhaps with Smithers, then we move to Harbottle, then we go to Net, and then maybe now Mabin, and maybe a few other cases that individual instructors may throw in there. But that's roughly the idea. And that case, as many of you may remember, oftentimes may be associated with the idea that there is the bare facts may be remembered without going into the details. So some people remember that there was a very heated hockey game between two rival teams, and the two main rival players had got into a fight or had a hostility between one another. And then following the game, there was a fight. Some may remember there was a kick, purportedly a hard, swift kick that is landed on the other. It results in the individual receive that kick to vomit, and due to a malfunctioning epiglottis, they unfortunately asphyxiate and perish as a result of that. The case stands for broadly a discussion on causation and how the legal test that comes out of that and goes forward. But there's a much broader history to that case that may not necessarily be revealed by just looking at the facts, as the Supreme Court of Canada tells us, written by Justice Dixon, but as a unanimous decision of the court. And so what I want to do is I'm going to be presenting a counter narrative and looking at a broader set of facts that was testified to and brought out during the trial, but didn't necessarily make it into the final rendition of the facts in the court's decision. And so in presenting that counter history, it's probably useful to think about looking at what the court actually did say. If you have a counter narrative, you usually have an original narrative that's being countered, of course. So in the next two slides, I'm going to read out, and thankfully the decision is fairly short. We can read through those facts and see how the court described what happened in the case. I'll provide a few general things to observe. I'll then move into talking about the theoretical framework that helped to inspire the writing of this article, particularly critical race theory. I'll go and have a brief discussion on the sources that I used to find this broader story, and then I'll go into deconstructing or counter-narrating the broader story. Okay, so please turn to the next slide. And so here we have on this slide, this is at page 508 of the decision. So the court starts off on February 18th, 1973. A hockey game was played between the Applewood midget team and the Cooksville midget team at the Cawthra Park Arena in the town of Mississauga. The leading player on the Applewood team was the deceased, Barry Kobe, 16 years of age. The leading player on the Cooksville team was the appellant, The game was rough. The players were aggressive and feelings ran high. The appellant, who is Black, was subjected to racial insults by Kobe and other members of the Applewood team. Following a heated and abusive exchange of profanities, the appellant, being Smithers, and Kobe were both ejected from the game. The appellant made repeated threats that he was going to get Kobe. Kobe was very apprehensive and left the arena at the end of the game. Some 45 minutes later, accompanied by 8 or 10 persons, including friends, players, his coach, and the team's manager, the appellant repeated his threats and challenges to fight as the group departed. Kobe did not take up the challenge. Instead, he hurried down toward a waiting car. Turning to the next slide. So the court continues. The appellant caught up with him at the bottom of the outside steps and directed 1 or 2 punches to Kobe's head. Several of Kobe's teammates grabbed the appellant and held him. Kobe, who had taken no steps to defend himself, was observed to double up and stand back while the appellant struggled to free himself from those holding him. While Kobe was thus bent over and approximately 2 to 4 feet from the appellant delivered what was described as a hard, fast kick to Kobe's stomach area. Only seconds elapsed between the punching and the kick. Following the kick, Kobe groaned, staggered towards his car, fell to the ground on his back, and gasped for air. Within 5 minutes, he appeared to stop breathing. He was dead upon arrival at the Mississauga General Hospital. Now, a little bit further down in the decision, close to the end, just as the court was about to very quickly dismiss the claim of self-defense, it stated the following, and I think this is important in terms of thinking about its characterization of Smithers and the overall gist of the case. The court states, although undoubtedly much upset by the actions and language of Kobe during the first 10 minutes of play, thereafter, the appellant alone was the aggressor. He relentlessly pursued Kobe some 45 minutes later for the purpose of carrying out his threats to get Kobe. So that's the narrative that the Supreme Court put in its decision. It's the narrative that every law student has read since pretty much 1978. And the main narrative probably that's been taught for the most part, although accepting that many colleagues and law professors may have added more details in as part of their lectures. But this is the main focus of what the court's narrative was. Now, a few comments before thinking about going through the counter narrative, a few things to observe here. So notice how the decision begins on February 18th. So that's the start time. Every story has a beginning. The court chose to begin that on February 18th, focusing on the events of that day. So to highlight here, was there any other information, context that preceded this date to suggest that might have impacted how Smithers reacted to the language that was used against him, specifically the racial slurs? The only mention that the court brings out with respect to race and racism was basically in one line. They refer to the fact that Paul Smithers is Black. Kobe's race, noticeably, is left out. Kobe's age, though, him being 16 years old, isn't specifically included, but noticeably, Paul Smithers' age is left out. He is also, by the way, he was also at the time 16 years old, but we leave that out for whatever reason. The court then switches over very quickly to talk about the nature of the game, and in almost summary-like fashion indicates that sure, Paul Smithers was subjected to racial insults by Kobe and other members of the Applewood team. No details as to the extent, the frequency, the nature of the words that are used, and again, how that might impact someone who's being subjected to those words. We notice the language of a heated and abusive exchange of profanities, which suggests something of equal weight, perhaps. Then we have the 45 minutes that elapses, and the idea that Paul Smithers was essentially chasing after and looking to have a fight to get Barry Coby. Nothing is mentioned about the idea of potentially seeking an apology. Then we transition to the fight itself, and the testimony at trial suggests two different visions or version of events that took place. The court essentially went with one version of those events. It left out the version of events as relayed by Paul Smithers on the stand, a version which I'm going to share with you soon. And what it also leaves out is that after the kick, what was Paul Smithers' reaction after these events? I bring all this up for a couple of reasons. When you read the narrative as the court provides us, what it suggests is someone who is unhinged, someone who has serious anger issues, and of course, it's someone who's racialized. They identify him specifically as Black, and in so doing, they don't, and in failing to provide a broader context and the further details, it essentially characterizes him in a very, well, shall we say, stereotypical and caricatured way. A former student of mine who I was talking about this with a couple of years ago said, and the student was Black, pointed out like the court's narrative essentially made him look like a savage. And I think that's a fair conclusion when you read the court's rendition of what happened. So now let's start down the road of deconstructing and reconstructing, re-narrating, counter-narrating what took place here. Okay, so turning to the next slide, slide 6, please. So I drew on critical race theory in trying to rebuild this idea of a counter-narrative and what took place. Now, a lot's been said in recent years about critical race theory. It started off originally within the context of American legal education, the legal academy. It's spread beyond the borders of the United States, and as well, its disciplinary borders to other disciplines, of course. And so while there's no time here now to consider the diversity here, there are a few points that we can look at that I've drawn on to engage in a type of history that I've done. So the first comes from Richard Delgado and Jean Stefankich. They have a seminal book on critical race theory. And one of the things that they point out, common to many critical race theorists, is the idea that central to critical race theory is the idea that racism is ordinary. It's not aberrational. It's systemic and it's widespread. Racism doesn't have to be overt. It doesn't have to come through via racial slurs or physical violence. It could be very subtle. Practices could seem neutral on their face, but have a disparate impact on a particular group of people. Now, in the context of the Smithers case, and in particular with hockey, because that's the realm in which this was operating, in addition to the criminal justice system, the racism that Paul Smithers experienced wasn't limited to that day. It was over a span of months, and he certainly experienced it in other seasons that he played. That racism, fluctuated in terms of degrees of horridness. There were some teams that he played that were excelled in it more than others, but he still experienced it quite frequently. It wasn't just, by the way, other opposing teammates. It may have been members of the audience, the spectators, who were also engaging on it loudly, I might add. And of course, Paul Smithers' experience wasn't unique. If you look at histories of hockey players, Black hockey players, what you see is a distressing history of repeated and systemic forms of, again, blatant and overt racism, going back to Willie O'Ree, to Mike Marson, who actually was only a year older than Paul Smithers in the 1970s, and who was recruited by the Washington Capitals. And you read their stories and stories of other players in the 80s and 90s, and you quickly see this is not something that has completely gone away, but it was certainly more blatant in your face and more frequent back in that period. And I might add, it wasn't as if there was any attempts, it seems, to stop that. So Paul Smithers had to endure this over many games without there being any kind of proper response to the racism that he experienced. So critical race theory helps to contextualize and think about the idea that the racism that Paul Smithers experienced was ordinary, not aberrational. Second, another facet of critical race theory is the manner in which critical race theorists have challenged stock narratives that often portray many people of color, Indigenous people, as in very stereotypical ways, as villains or as objects or as characters who are oversexed. And in impugning and challenging those narratives, scholars have offered different types of narratives, counter-narratives. And these counter-narratives can take several forms, right? So on one hand, some could be autobiographical in nature, talking about their own experiences of experiencing racism, but maybe even talking about resilience and resistance. Other types of counter-narratives can be written in the third-person form. They could be biographies, parables, poems, histories, revisionist histories about the experiences of racism. And third is a very interesting form of counter-narratives called composite counter-narratives. So it's a compilation of different experiences, actual lived experiences, but in a creative format. And one scholar that I read last year, Dr. Kanika Samuels-Wortley, wrote a wonderful article on looking at the voices of Black and Indigenous youth and their perceptions of policing. Great article, highly recommend it. So the approach I've taken is to take the second approach, which is biographical. Mind you, it's a very narrow biography, right? It's not capturing the richness of Paul Smithers' life. It's focusing on this one moment. It's third person, I'm writing it, and it's meant to be it would probably qualify as a revisionist history. So with that sort of background in mind, let me just turn to the next slide quickly, just talk about my the sources I used. Okay, so largely the way I reconstructed this history is by examining the trial transcript. So there's 5 volumes. Volume 4 was largely focused on the defense witnesses. Paul Smithers included as a lead witness, and then subsequent other witnesses, including fellow teammates who testified as to what they observed about the racism that Paul Smithers experienced, in addition to parents of some of these players who were in the stands who noticed the spectators involving themselves in this type of racism. And then also, I supplemented this by looking at a series of newspaper articles from the 1970s itself. So I looked at actual trial coverage of the Paul Smithers trial in 1974 in April through the Toronto Star and the Globe and Mail. In addition, after the trial and the verdict came in, and over the next couple of years, there are a series of articles written about the case and a number of interviews done with the Smithers family, as well as the Kobe family and others. So that included an article by Dan Proudfoot in Weekend Magazine, as well as 2 articles, one in the Washington Post and the New York Times. So this, just to give you an idea here, this, we read this case every year, and, we know what happens in Canada. It's written by the Supreme Court of Canada, but we don't realize that back in the 70s, this case happened to actually make big news. So much so that 2 big major newspapers in the United States felt the need to actually send 2 reporters to cover it, to do interviews at the time. And those 2 articles have a number of interesting quotes and information that comes from this. So I relied on all these sources to build together this counter narrative. So now turning to slide 8, getting to the actual counter narrative now that I've set everything up. So thinking about this, the events prior to February 18th. So if you take the court's narrative at its word, it seems that the only thing we should be looking at is what happened on February 18th. Turns out a lot of other things happened. And some of those things were the actual context that Paul Smithers experienced a significant degree of racism through the time that he was playing, particularly in that season, but in other seasons before. But focusing on that season, starting from September onwards, there were several teams that they played, the Cooksville team that he was a member of, but 2 teams in particular targeted him in particular with racial slurs. That included Barry Kobe's team, which was the Applewood team, and Malton. But it wasn't just those teams. He felt it and experienced it amongst other teams. So things that, and by the way, it wasn't just Barry Kobe in previous games that apparently said this to him on use these racial slurs in past games. So he was getting called these names repeatedly. And without any response, any penalties given out for it, so far as I could tell from the record. So this is building up and it's building up. And one of, although Paul Smithers had testified that he tried not to let it bother him, and he just sort of took it, one of his fellow teammates testified that Barry Kobe in particular had used those slurs quite often when they were playing. So that's the context leading up to February 18th in part, but there's more to it. 2 weeks before the February 18th game, I recognize that members of the family, the Smithers family, may be in attendance, so I don't want to go into too much detail on this, but after one game against the Malton team, this is one of the 2 teams I mentioned that were particularly prolific with the use of racial slurs with respect to Paul Smithers. After the game, Paul Smithers and his mother, Joyce, were walking back to the car, and then a series of players from that team started to use a number of horrible things directed at Paul Smithers' mother. I won't say the words, it's in the article, but just understand they're both misogynistic and racial in nature. Remember, actually, I may have mentioned this before, Joyce Smithers was white. Paul Smithers' father was Black. So there were a number of epithets thrown at her at that time. Paul Smithers, who I think from the record that I've seen seems to have taken the slurs sent at him in stride with respect to his mother, he not quite naturally lost his temper, and no one could blame him. 2 other individuals restrained him, and as a result of his mother, pleading with him to get in the car, he did, and they went off. But Paul Smithers had talked about how the result of that event, that incident, had an impact on him and stayed with him for some time, really bothered him. And he said, I think in an interview with the Washington Post, that probably stuck with him 2 weeks later when we got to February 18th, even though it wasn't Barry Kobe who did it or said it. It's the upswell, the accumulation of all these racist events leading up to February 18th. So we get to the game. Now, this is bullet 2. What happened in the game is the court does in a very, again, succinct way. The players were aggressive and feelings ran high. The appellant, who is Black, was subjected to racial insults by Kobe and other members of the Applewood team. Following a heated, abusive exchange of profanities, the appellant and Kobe were both ejected from the game. That's it. That's all we know about what happened in the game. But there's a lot more, a lot of racism in any event. In addition to that, a physical assault. Okay, so they're playing the game. Paul Smithers tells us at trial that somewhere 7 minutes into the game, at one point there was some jockeying around for a hockey puck in some corner. At some stage, the referee blows the whistle. Play is stopped. Kobe turns to Smithers and calls him some words and yells at him as if Paul Smithers did something. turns out, at least according to Paul Smithers, nothing actually happened at that point that he did in any event. Other testimony suggests that, alleges that Paul Smithers speared Kobe with his hockey stick. Others suggest in other sources that I came across that it was alleged that another Cooksville player may have elbowed Kobe, but it wasn't Smithers. But nevertheless, Kobe thought Smithers had elbowed him or speared him. So he got very angry. And then within a minute or two after that moment, there was action on the ice and Kobe speared Paul Smithers with his hockey stick. The referee saw it. He gave Kobe a penalty for 5 minutes. So that pretty much displeased Barry Kobe at this point, not surprisingly, because he thought that Smithers did the same to him and didn't get caught. So he's yelling and at Smithers, saying he essentially throwing out the idea that he's not scared of him, that he's prepared to fight him, and he's using racial slurs. He's then put into the penalty box at the insistence of the referee. Now, what does Paul Smithers do? Does he respond? Does he retaliate? He actually does what he's supposed to do. He focuses on the game. And because it's now a power play, he was the star player of his team, from what I understand, he goes and he scores the goal. After he does that, while Kobe is in the penalty box, he's apparently still yelling racial epithets. He's in the penalty box, by the way, with someone who's witnessing this, timekeeper. So he's talking about how he's going to, Kobe is saying how he's going to get Smithers. And he's again using racial epithets as he's saying this. Paul Smithers, on his way back after scoring the goal, said something to Kobe as he was in the penalty box, something along the lines of, showed you up, or something along those lines. This, again, it generated further response from Kobe, more racial slurs, slurs by other teammates, and apparently others from the audience at this point. The referee at this stage says to Kobe to stop it. He refuses, and then he ejects him from the game. He then skates over to Paul Smithers and says, okay, you're out too. Now, at this point, Paul Smithers is like, what did I do? What did I even possibly say to get booted out of this game? Apart from maybe, showed you up, as if that anywhere compares to what he's been called for the past several minutes. So he's ejected, and he's awfully angry at this point. And he's been threatened, dared by Barry Kobe. By the way, this was witnessed by other people. This isn't just Paul Smithers saying it. He's being challenged to fight repeatedly. So they're now ejected from the ice. They're downstairs near the dressing rooms. And he approaches Kobe. Kobe had a friend with him. And he says, do you want to fight? And then Kobe says, oh, you shake me up, as if to suggest I'm not scared of you. They go to their respective changing rooms. They change. Smithers comes out of his dressing room, and you could see the door slightly ajar. He's just waiting outside the Applewood locker room. And out comes the team manager, John Lockie. And he basically says, is he going to come out? And he says, no, he's not, or something to that effect, and says, mind your own business. And again, Paul Smithers is very angry at this point, and he wants to settle this. He's tired of being called the N-word and other racial slurs over and over again. And so he decides to, he wants to settle this. The door is slightly open, and Paul Smithers says they're just basically sneering at each other. At some point, a rink attendant says, listen, if you want to fight, you got to take it outside. Not don't fight, but if you want to fight, take it outside. Okay. So in a moment or two, Kobe leaves the dressing room with a few friends. Smithers asks again, do you want to still fight? And Kobe says, basically tells him, just shut up. Doesn't really answer him, and doesn't seem to like he wants to engage in a fight, but then it doesn't seem to be cowering or completely apprehensive either. So Kobe and his friends go up to the rink. Paul Smithers situates himself somewhere else, but he's still looking at him, but also angry. He's also angry at this stage, not only at Kobe, but also the referee, who essentially threw him out of the ice for what he believes is for not doing anything that justified it. So he's getting into, he's starting to say things to the referee. The referee says, stop that or else I'm going to suspend you for the season and I'm going to stop the game. Paul Smithers doesn't relent, and so the referee actually makes good on his promise, at least stops the game. Smithers then follows the team, the Applewood team, his opposing team, out back to the dressing room, again, seeking to find out from Kobe whether he still wanted to fight. And again, he's being told to shut up, and he's called by another player a racial slur and saying that Kobe is going to have to beat him up if he doesn't shut up and leaves it alone. Smithers goes back to his locker room with his teammates, and they ask him, well, what are you going to do? And says, well, I'm going to see if he wants to fight. And they all say, or a few of them say, well, wait till we get dressed and we can go out and do a Donnybrook. This is an interesting 70s term, I think, for a brawl. Smithers says, nope, I'll do this myself. This is my fight. So he's alerted to the fact that that Kobe is about to leave with a series of other players, and it turns out, I think the coach and the team manager. As they're leaving, they're going up the stairs. Smithers tells us in testimony that he essentially says, apologize and we'll forget about it. We'll just let it go. Kobe's response, according to Paul Smithers, is something akin to, me apologize to you? So Kobe and his teammates and the coach leave the arena. Now notice there's nothing in the court's narrative about that apology or that it was testified to in the narrative. So as they leave, Smithers follows along somewhere, I guess, in back of them. Kobe is now exits the building and starts to walk down the stairs outside the arena. As Smithers leaves, he's restrained by I think the team manager. The way the court talks about this is that Kobe was very apprehensive to fight. In fact, hurrying down the steps to get to his awaiting car so he can avoid a fight. Now, what's interesting is in the Crown's respondent factum, they talk about the idea that, in fact, 3 different Crown witnesses identify that Kobe was not, in fact, rushing down the steps, but in fact, seemed to walk normally. In fact, one said he seemed to be taking his time, I think. So what this means is we have conflicting testimony, even amongst Crown witnesses, about how hurried Barry Kobe was to avoid a fight. Now we get to the fight, and this is also very key. So the way the court lays it out is that Smithers approaches Kobe and directs 1 to 2 punches right away. And to the suggestion that Kobe did nothing to defend himself. The way Paul Smithers tells us in testimony is the following. As he's approaching Kobe is actually standing with his arms in a 90-degree position. In other words, looking like he's prepared to fight. So at this point, in a very quick way, Smithers delivers apparently 1 to 2 punches in Kobe's direction, and he testifies that he grazed Kobe's chin. He's immediately restrained by Kobe's teammates. Now, the way the court describes this is that the teammates grabbed the appellant and held him. This almost suggests a very neutralizing, almost neutral way of just holding him there. And then at some point in all this, Kobe's already bent over, and then Smithers then delivers supposedly a hard, fast kick to his stomach, suggesting a rather cheap shot and attacking someone who's already in a vulnerable position. Now, the way Smithers tells us is something different. He's not only just being held, he's being actively restrained. There's one player, individual, who's behind him, who has their arm right around his throat, Smithers' throat, and yanking back. 2 other individuals, one on each arm, is holding him back. So they're pressed up back against a vehicle. And somewhere in the fast series of events, what Paul Smithers notices is not a doubled over Barry Khoday, but Barry Khoday is standing upright and looking like he's about to come and hit him, whether kicking or punching. It's at this stage that the leg raises, and whether you call it a kick or a leg movement, it strikes Khoday apparently in the groin or the stomach. That's when the vomiting happens, the asphyxiation because of the malfunctioning epiglottis, and then finally and then subsequently his death. Now, when you think about the nature of the kick here, we have to remember he's being held back. I tried this yesterday at home again just to see what this would be like. There's a difference between standing upright and the force that you can deliver with a kick, and when you're being held back. Now, I just did it by standing back against my kitchen table and just sort of standing a little bit, arched a little bit backwards. And I tried to lift my leg in that particular context. And trust me, at least for my experience, maybe it's just my age, but the force of which I could kick someone or move my leg was very weak. And he was being aggressively restrained back. So the extent to which he could deliver a hard, fast kick, in my view, is questionable. And just to point this out, on the stand, Paul Smithers said that at the time, he was in shock by the idea that this could have done anything, because what his recollection was that this wasn't a hard, fast kick. It was a very weak kick. It was hardly one with any force. And he said that as much in the moments after the fight, and as Mr. Khoday was suffering on the ground and then subsequently passed. So we have a very different series of events that took place, that relayed in different ways by different sets of witnesses. You have the Crown witnesses and Smithers, who was the only one that around. But what's interesting, and this is important, there was one Crown witness who witnessed the kick. And that witness indicated that given the nature of how Smithers was being held back, the leg, the kick or the leg being raised wasn't to what they refer to in the factum as up to the kicking point. I take that to mean it wasn't to a point of a really forceful kick, or even to one that went very high perhaps, but it certainly contradicts the idea that this was a hard, fast kick. And the basis for thinking about how Smithers was a contributing cause of death outside the de minimis range. Then we get to the fight itself. And I just want to say a couple of words about this in the court's construction of what took place here. You know, we see again, Paul Smithers being characterized in a certain way, this sort of vengeful individual who's looking to get Khoday, after the fight, he was immensely distraught, in shock about what was happening. This certainly wasn't his intent, and as by his own testimony, he was preferred to actually just get an apology and move on. So what happened was he's waiting there with the parents of one of his teammates, and one of the individuals came outside saying, "I hope you're satisfied. He's dead or he's hurt." And Paul Smithers is just in shock again. He said, I just couldn't have kicked him that hard. The police arrive. One constable checked on Barry Khoday's pulse, realizing that there was none. He goes in. I guess he's informed about who did it. They go in. He approaches Paul Smithers, and Paul Smithers says, "I'm the one you're looking for. I'd like to talk to my parents first." In escorting Smithers to the car, Paul Smithers, again in shock and sobbing, talks about how all he was ever called by Khoday was the N-word repeatedly. "That's all I got." He said other things. I'll just speed it up here. And then he's sitting in the police cruiser crying, upset by what happened naturally. And then he's ultimately told that Barry Khoday has passed. And so he sobs some more, and then subsequently the court again goes into its discussion the medical evidence that was presented at trial. So what we have here is in this counter narrative is a much different vision of what happened that day. Paul Smithers is an individual who's not just some angry person. He is someone who was rightfully angry, but didn't just go seeking out a fight. He did look for an apology first, again, by his narrative. Now, what's problematic is the fact that the court didn't relay any of this information to the public. And so when we have the facts presented to us, it's done in a very authoritative way. This is what happened. No context, no nuance, just Paul Smithers is an aggressor and he alone was the case. So for most of the game. So I'm going to just try to finish off with a couple of points on the prosecution and the jury, and then we'll close up. So turning to the next slide. So the prosecutors themselves had an interesting role to play in this case with respect to minimizing the impact of racism that Smithers experienced. So on one hand, when Smithers was on the stand, the lead prosecutor, Leo McGuigan, was asking him about his perception, Smithers' perception of being called these racial slurs. And long story short, the way the questioning, proceeded was either that, well, you seem to be called these words so often, you must have been used to it. So therefore, were you really upset by being called these words? Or in the alternative, if you were upset, weren't you just being overly sensitive about being called the N-word repeatedly over and over again? And Smithers' response was, look, it bothered me. I try not to let it bother me, but it did. But in Kobe's case, he wasn't just doing it in the heat of the moment. He was doing it repeatedly to suggest it was more than just in the heat of the moment. Not that that justifies it, of course, but the way Smithers testified to it was that it was personal. He was doing it excessively, as Kobe was. In addition, one of the co-prosecutors, John Greenwood, stated something interesting, and I think it was the article in an interview with the Washington Post. If you take away Smithers' color, there wouldn't be so much attention given this case. If Smithers were white, there probably wouldn't be so much public concern. He probably would have been convicted, and that would have been that. Now, that's an interesting statement to make when you think about the fact of whether this would have happened in the first place. If he were white, there would be no reason for Paul Smithers to chase after Barry Kobe, because he wouldn't have been called the N-word in the first place, and he wouldn't have gotten these threats. So it's a rather strange statement to make, but that's what happened. It was in an interesting way, a very explicit call to colorblindness in this particular case, in a case factually where color and race were very much a part of the factual matrix. Turning to the next slide. So lastly, I want to just draw attention to the interesting thing that we don't get from the Smithers case itself was the fact that there was the reality or the potential for jury bias in this decision. A lot of us know that in 1993, in a case called Parks, the Ontario Court of Appeal recognized in a case dealing with the potential for racial bias, in particular anti-Black racial discrimination. The court recognized the extent to which anti-Black racism exists in the province of Ontario, because that's where they're focused. And so imagine that was 1993. This is 1973, and the trial was in 1974. So it came out in 1975. Leonard Kobe, who's Barry Kobe's father, had sat through the trial and read through the newspapers. He too worked for the Toronto Star at the time, I think as a pressman. And he was particularly alarmed and upset by the way in which his son was being characterized as a racist, notwithstanding the fact that numerous people, including Crown witnesses, were testifying to the fact that he was using these racial slurs. But leave that aside, he was very angry by this. And he said in a comment to, I think it was Dan Proudfoot's article, it was so slanted. I mean, we know one of the jurors, she lives near here, who said she knew after 2 or 3 days of the trial that the quote unquote black basket was killed. But anybody reading the newspapers bloody well wouldn't have been able to come to that conclusion. So interesting here. the trial started on April 8th and lasted at least till April 18th, as I recall. So that was at least 9 days, not counting the weekend, of course. 2 or 3 days of the trial. So they were still in the midst of Crown witnesses. And by this point, this juror says that she knew Paul Smithers was guilty. What that means is we have at the very least at the very least a reasonable apprehension of bias, if not actual bias. And the term black basket, first off, I'm not even sure where that comes from. If it's obviously in reference to Paul Smithers, but it's an odd term. But in any event, whether that came from Leonard Khoday or the juror themselves, it's hard to know. Another interesting facet, another thing came up. So what happened as a result of this quote is that Smithers' counsel at the time, Roy McMurtry, who went on to, of course, become Attorney General of Ontario and then subsequently a member of the Ontario Court of Appeal, ultimately becoming Chief Justice of Ontario. He files an application to the Federal Minister of Justice on the basis of this quote by Leonard Khoday, indicating that this was the ultimate outcome of the trial, rendered it, this jury bias rendered it in a miscarriage of justice. Arthur Maloney, who was Paul Smithers' trial counsel and counsel before the Ontario Court of Appeal, had learned, apparently, I think the year before, after the verdict, purportedly a daughter of one of the jurors in the case had expressed to another lawyer that she was surprised that her mother was impaneled because there was only one person who disliked Black people more than her mother, and that was her father. So suggesting again that her mother was not an unbiased person and should not have been one of the jurors. Now, it's not entirely clear to me, and it wasn't in the record. I kind of assumed for a while that they were talking about the same persons, but it's possible. There's 3 women jurors and there are 9 male jurors. All of them were white. It's possible that we're talking about 2 different jurors in this case or the same one. Either way, one juror is enough to render a decision a miscarriage of justice based on racial bias. To the next slide, please. So concluding my thoughts here, and I know I've been going on quite a bit, so I apologize. One of the goals of creating this article is, a year after year, once I found out about some of these broader facts in the case, I had to start talking about it to my class and conveying it. But then I thought, well, who else knows about this? So I wrote this article, and my hope is that in telling this broader story, that law students, as well as colleagues across the country, when they're teaching it, can sort of have something to draw on when they're teaching this case, to say there's a bigger side of this story. It wasn't the way that the court, solely the way the court may have portrayed it. There's no dispute that Paul Smithers experienced the racism that he experienced. The Crown wasn't disputing that. So all that wasn't disputed. Perhaps it was in dispute as to the way the fight took place at the end, but that doesn't stop the idea that maybe it was the court's responsibility to not create such a one-sided version of events, to just acknowledge that there was another side, Paul Smithers' side, and those of the witnesses. And at the end of the day, it was still open to presumably a non-racist jury to come to the conclusion that they decided to believe one side over another. But at the very least, that story should have been shared to a broader public. Whether the court realized that their decision would be read year after year and become a seminal case within Canadian criminal law, it's hard to know. But the result is all the same. Since 1978, how many hundreds of law students have heard and read this version of events? And year after year, this is not a case that one of several numerous Supreme Court of Canada cases that gets to be forgotten, put off into obscurity. This is one that we get to read every year, and Paul Smithers' name is raised every year. So my goal here was to sort of give his voice a chance through his testimony, through interviews he gave, to at least get his side of the story out. And of course, you can anybody can decide what they feel about it all the same, but that was really the goal of this. So I'm going to turn to the next slide. Thank you very much for your attention. I really appreciate it. And I'm open to any questions now from the audience. Thank you.
Thank you so much, Professor Amar.